So, what happens to your trust and the things inside of your trust after you pass away? This is estate planning lawyer Michael Pevney, and I create estate plans for families in California. So, when you set up a trust, a living trust, that's what I do for most of my clients. I set up revocable living trusts. And when we initially set up and create that trust, you or you and your spouse are in all three of the key positions. You are the grantor, meaning you put things into the trust. You are the trustee, meaning you have control of everything inside of that trust. And you are also the beneficiary, meaning that you benefit from things inside of that trust. And if that trust is funded properly, meaning there are things inside of that trust. I often compare a trust to a bucket. Okay, so we have to fill the bucket, put things inside of that trust. Might mean deeding a house to the trust, might mean titling certain assets like a checking account or an investment account to the trust, and maybe that also means making the trust the beneficiary of certain financial instruments like retirement accounts or like other investment accounts, that sort of thing. So once things are inside of the trust, or the trust is the beneficiary of these accounts, and we pass away, or we and our spouse also pass away, the trust still exists. But what happens on a very practical matter? So we're always going to have a successor trustee. That's the person that takes over the trust after we're gone. That's the person who's left holding the bucket. And I don't necessarily mean that in a bad way. They're now in charge of the trust, but they don't get to do whatever they want to with that trust. They have to follow the terms of the trust that we set out when we initially wrote and created that trust. So basically what happens is if I'm on a bank account, it would say Michael Pevney, trustee of the Michael Pevney Living Trust. If I have a brother named Mitch, he would basically go to the bank. If he's my next trustee, he would get a death certificate and maybe a copy of that trust. The bank might need to see a copy of the trust, and he'll say, hey, I'm Mitch. My brother Michael passed away. I'm next in line. I'm the next trustee. And now he has control of that bank account. Same thing with the deed to the house. He would go in and file a substitution of trustee or a death of a trustee affidavit along with a death certificate. And his name would then be on the deed to that house, and he would now have control of that house. But Mitch, my brother, doesn't get to do whatever he wants with that. He might have to use that money to take care of my kids. Now, Mitch may or may not be the guardian of my kids after I'm gone. In fact, he probably won't be. But he's going to have to use the funds, the money in that trust. Maybe he'll sell the house, which he now has the authority to do. Maybe life insurance is going to be left to that trust. So the life insurance is going to go into that checking account with him as trustee, and he's going to start distributing money, paying for school, paying for somewhere for my kids to live, paying for their college, and then distributing things along the way as it goes. So that's basically what happens when you pass away with a trust, what a trustee then does. So the trustee basically, initially, they kind of have to go around to different county offices and financial institutions and submit a bunch of death certificates and sign certain affidavits. One thing that they do not have to do, though, is go to court. The whole point of a trust, one of the big points of a trust, there are other benefits, is to avoid probate. We want to stay out of court because the probate process is so expensive and it is so time consuming, and we want to avoid that. We want things to be handled privately between us and the bank, or between us and the realtor. And so that is, as a practical matter, what ends up happening. Now, if this trust is going to exist for a long time, and I have kids that are younger or under 18 or under 25 or 30, because I don't want them to get all that money is going to stay in the trust. And the trustee is always going to be empowered to get help. They might need, as this trust is existing and distributing money, they might need help from an accountant. The trust says that the trust can pay for, and they can get help from an accountant. The trustee doesn't have to pay for this out of pocket. It comes from the trust. They may need an investment advisor to make sure that those monies are responsibly invested. They may need to get help from a lawyer. They may need to get an accountant to file a tax return, because when a trust becomes irrevocable after the grantor or grantors have passed away, they are going to have to, a trust is going to have to file taxes because a trust may very well make income and that's a good thing if things are properly invested. So that's, as a practical matter, what happens to the trust after the initial trustee, the people that created the trust, both the grantor, who is also the initial trustee, passes away. If you have any questions about this or anything else related to estate planning, you can set up a time to meet with me for free by going to ocestateplanninglawyer.com. Thanks for your time and thanks for your attention.